We have new documents in the Idaho 4 case, but honestly, they're nothing special. Hey guys, this is Jules with True Crime Reactions. Disclaimer. Everything stated in this video is my opinion and my opinion only, and just like everything else in these cases we discuss here on this channel, everything is alleged. Okay, we have a couple of documents that dropped yesterday. Most of you guys know I had to leave yesterday. I had a family thing I had to take care of, so I'm a little bit behind. I still am going to be getting out a federal grand jury versus state grand jury video just so we can try to understand why this was said.
For defense's fourth motion to compel, Item 1, Subpart A, discusses federal grand jury materials. Those are exempt from disclosure by federal law, as well as Idaho Code 74-104, subsection 2.
Yeah, very interesting, isn't it? Okay, now let's get to these documents because honestly, it's literally just the motion for the 14th officially being closed. But the document is weird. I'm trying to figure out what exactly the document is. It probably is just like a clerical error, but it's just strange looking. I'm gonna show you. Okay, we have this motion to tip seal motion. This is the one I'm talking about. Like it's weird looking, but I think it's just because it's the Duces Tecum subpoena for the feds. At the end of the last hearing, they had a Duces Tecum subpoena signed by Judge for the cast report because 17 months later, we still only have a draft, even though, there's stuff about it in the probable cause affidavit. The state still doesn't have access to it. So I don't know how they wrote that thing, not having actual reports to read. So that's what this is because they're sealing it. I don't know why they're sealing it whenever we've already known what this is. We know exactly what this is. I don't know why they're doing this. Motion to temporarily seal motion and order for issuance of subpoena Duces Tecum and subpoena Duces Tecum pending hearing. Okay, I guess they're going to have another hearing at some point, another useless hearing. But this is just, yeah, see, this is just the protective order. I don't know. I don't know why they're being so stupid now. It's just dumb. Okay, order granting state's motion to close May 14th, 2024 hearing. Now, he made this decision at the hearing this week. On the hearing that we just had on Thursday the 2nd, he made this decision. Before the argument was even done, before the session even started. Okay, honestly, let's just be honest here. Before the court session even started, he'd already made up his mind. Let's go ahead and read this and see if any new information is in this. I doubt it because it's from the judge, but let's find out. For the reasons articulated in the record during the May 2nd, 2024 hearing, the court orders the hearing on defendants' fourth and fifth motions to compel, set for May 14th, 2024, to be sealed to protect the parties' right to a fair trial. During the hearing, it is anticipated that the parties will discuss specific items of discovery that may or may not be admissible at trial. Then why are they allowed to even have them in the record? See, there was some crazy stuff about things that might not be admissible that I learned when it came to these grand jury things too. So I don't know why they're allowed to even talk about things that are not admissible. We're just going to skip over that and keep reading because I'm just going to get aggravated, and I'm really not trying to be aggravated today. The disclosure of such evidence to the public at this stage of the case is not appropriate and may prejudice the jury pool. Further, the parties have stipulated that all attachments to discovery request and responses be filed under seal pursuant to ICAR 32 I2D and E and IC 74-1241B and C because the document contains facts or statements that might threaten or endanger the life or safety of individuals. It is necessary to preserve the right of a fair trial, and disclosure would constitute an unwarranted invasion of personal privacy. We heard in the motion that it was going to be private citizens. They're still talking about training records, so I don't know if that's going to be discussed on the 14th or not, most likely. But then also names of businesses and things like that. But the probable cause affidavit lists Albertsons and a coffee shop. So it must not be those two that they're trying to protect if those names are already out there. The hearing on May 14th, 2024 will deal directly with various attachments to discovery requests and responses that are sealed. If issues arise that should not be sealed and should be addressed at a public hearing, the court will hold a separate open hearing at a future date to ensure the victims' families have prior notice and an opportunity to be present at any open hearing. Oh, well, if there's some public information that needs to be discussed, then we'll just waste some more time and schedule a whole separate hearing. Dumb. The hearing on May 14th, 2024 will not at any time be open to the public to ensure the victims' families are afforded every right under Article 1, Section 22 of the Idaho Constitution. Well, let's just see what that is. Search the webo. Section 22, Rights of Crime Victims. A crime victim, as defined by statute, has the following rights: to be treated with fairness, respect, dignity, and privacy throughout the criminal justice process, and to timely disposition of the case. Okay, well, it being public or not, why can't they just create a Zoom link and be like, hey, it's closed, but in case we open it, we'll have somebody send you out a message a few minutes before we open it, and then you can get on the link. Just be ready. Instead, they want to waste more time scheduling and all this other crap. It's so stupid. It's so stupid. Okay, so now we have the order setting disclosures deadline. Now, they had like week on, week off type deadlines, and then the defense team was like, no, let's do dual deadlines where everyone's stuff is like due at the exact same time when it comes to like expert witnesses and stuff like that. I think that they need to do that so they can just get this all done. Like, we need to get to where the facts are being presented, because all of this is such like, they're just beating around the bush. This is the stupidest crap. So they were discussing the whole scheduling thing for when they were going to be getting stuff turned in. Let's see what they came up with. Based on the May 2nd, 2024 hearing, the court orders the following: any witnesses, including experts, expert reports, if any, a summary of what each witness is expected to testify, and exhibits the defense intends to present at the May 14th or May 16th hearing on defendants' 4th and 5th motions to compel must be disclosed to the state and filed with the court no later than May 7th of 2024. So, if in this hearing they decide to bring Cy Ray in, then they would have to have a summary of what Cy Ray is going to be discussing and any exhibits he's going to be using to, I guess, show them how his calculations are done, because he can't be like, oh, well, because of my calculation, we found out that Bryan was here, pop it on a map in a hearing. Okay, that's a trial situation. This is him. Like, he would literally just be going in there the same way the survey guy did, explaining how the survey is put together, explaining what parts were used to create the survey, right? Then it would be a summary of what he's there to testify to. And obviously, like, his credentials probably would have to be in there again. And then it would be like parts of data that are used to put together, and like examples would sort of be shown. That's what they need to have so that the state has a chance to like go over it before it happens, which fair is fair, I guess. Any witnesses, including experts, expert reports, if any, a summary of what each blah, 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 blah. Okay, so it's the same thing, just reverse. So the first one is the defense has to do this for the state, and the second paragraph is just the same exact thing, but whatever the state tends to show, they need to have their same exact summaries and informations and data points and everything handed over to the defense 3 days later on May the 10th. Now, this is the last one. Temporary order, sealing motion, and order for issuance of subpoena. Okay, yeah. It's the exact same. It's the same crap that we went over the first thing. But yeah, see, nothing new at all, really. Just stuff we already knew was going to happen because of the motion hearing, but they have to put everything on paper. If it's on paper and if it's part of the case, we go over it. But that's it. I want to know what you guys think about what's going on so far. In the video that I'm going to be putting out tomorrow, hopefully, fingers crossed, nothing else goes crazy like it did on Friday. It'll be about the grand juries, but the federal grand juries versus the state grand juries. I don't really have a lot of very specific things, but I have a lot of questions, and I really hope I have answers for those questions to put into this video, because if not, then there's going to be questions in the video that we collectively were going to be trying to find answers for. But that's it. Let me know what you guys think about all of this insanity down below. If you like the way that I present this information and give my opinion, please do not forget to leave a like on your way out and subscribe to the channel if you are not subscribed already. See y'all.